Thank you, Mr. Chairman. Director Cordray, as you know, the committee has at length raised concerns with the guidance the Bureau issued in 2013, which it dubiously claimed is a simple interpretation of its authority under ECOA. Despite explicit language and intent in Dodd-Frank to exclude automotive lending from the Bureau purview, we've also taken issue with the disparate impact theory and the questionable methodology used by the CFPB to administer it. This is also a major concern for my automobile dealers in my district and also all across Illinois. You've now relied on disparate impact theory of discrimination under ECOA in at least 3 separate enforcement actions against businesses that underwrite auto loans. I suspect that what you're doing is extending the Supreme Court's holding in the Inclusive Communities case, but that case dealt with the Fair Housing Act, not ECOA, and that decision rested primarily on the unique congressional history of FHA, history that is plainly inapplicable to ECOA. Wondering if you could spell out in detail the specific legal basis on which the CFPB is pursuing ECOA enforcement actions using disparate impact.
So I believe there was a considerable hope among a lot of the industry that disparate impact would be disapproved by the Supreme Court. And by the way, I understand interesting news, we have a new Supreme Court nominee this morning. And that was a challenge that was raised in the Inclusive Communities case that you referenced. And in fact, the Supreme Court resoundingly upheld disparate
That was an FHA case, right?
That is correct.
This is an ECOA case, right?
Yes. But
very different, very...
No, I don't think so.
No, it's very different.
I don't think so.
very specific.
I
requirements that we've got there were laid out, housing, fair housing.
Look,
but you're, I think, extrapolating something that we just can't find any rationale for.
2 laws have been applied hand in glove for decades.
ECOA specifically had exemptions for this,
ECOA
and yet you were using that.
Market, and they work together in the same
transaction. The sense that we have is you're just pulling this out of nothing because there's an agenda that's being pushed.
That's look, again, if
move on.
that had been upset, we wouldn't be enforcing the law.
We talked a little bit about HMDA, and I want to ask you specifically about some concerns, privacy concerns. My colleague from Georgia, Mr. Westmoreland, raised some issues of the amount of data that you already have, specific data on individuals, and all of us have concerns. Federal government, I think, showing incredible weakness of being able to protect the privacy of our citizens. I hear it all the time from them. The recently finalized HMDA rule is especially concerning to me because it looks like it's not enough. All the information that Mr. Westmoreland had listed off, item after item after item, and now it looks like CFPB is looking for more of private information that I question if it's safe. Section 1094 of the Dodd-Frank Act, which made changes to HMDA, also required the Bureau to develop regulations that, and I quote, modify or require modification of itemized information for the purpose of protecting the privacy interests of the mortgage applications or mortgagors that is or will be available to the public, end quote. In a footnote to the final HMDA rule in October 2015, the Bureau states, and I quote, based on its analysis to date, the Bureau believes that some of the proposed new data points may create privacy concerns sufficient to warrant some degree of modification, including redaction before public disclosure, end quote. However, the Bureau is only providing opportunity to comment on the balancing test for consumer privacy, not the actual data made public by FFIEC. In a 2005 speech, former Federal Reserve Board Senior Advisor Glenn Cantor raised concerns about HMDA privacy risks, noting, and I quote again, approximately 95% of loan records are unique, meaning loan amounts and census tracts can be attributed to a single person. With a cross-match to private lien transfer records, one can identify these individuals in 95% of the cases, end quote. Shouldn't the Bureau proceed with extreme caution before finalizing any policy that would direct FFIEC to publish additional consumer information, even if steps are taken to anonymize it?
So thank you for the question, and as you pointed out, and I think you should be pleased, we are approaching this issue of the privacy issues very sensitively, and we have engaged in a further notice and comment.
I'm not pleased, and my consumers are not pleased, my banks are not pleased because they've seen breach after breach after breach by the federal government. Mr. Westmoreland asked, who's the company that's looking at it? You said there isn't one, basically. It's internal.
No,
we've seen failures over and over again. And now my concern with HMDA is you're going to be getting more information. It's stated by people in the administration saying that this does identify people, that 95% chances you're looking through this, we can know exactly who it is, even if it's anonymized. I don't think it's enough. My citizens are concerned,
Yep.
and now you're adding more requirement of getting more private information of my citizens. I think it's wrong. I think you ought to, all of us ought to proceed with extreme caution.
Yep.
To me, the least you could say is, yes, we will proceed with extreme caution. I yield
We will
back.
proceed
Time
very
to the
carefully.